First you get it investigated. Yes, we know, we the bar know that the judges are above board. They are the most honest persons that can be found in the entire judiciary. However, to protect the independence of the judiciary, independence of the legal profession and the cause of justice as neutral and impartial and beyond doubt, Caesar's right should be beyond doubt. It is important the Bar Association takes a stand by intervening in such matters and telling that there must be a need for an independent probe. A JPC and retired CJA and jurist probe can be initiated. There must be a permanent mechanism that is going on. You see, there is this context, it is important to discuss the SCAOR case. See, after that, they told that yes, it is settled law that the Chief Justice shall be consulted before any matter concerning judiciary in appointments or in dismissals or any conduct based investigation. The Chief Justice shall be consulted. No question. It is a landmark judgment. We all welcome the judgment. However, there is a requirement of, okay, in case the Chief Justice himself is alleged of any offence, like in the Kalikopul case, then what is the system? Whether the system has such mechanism. It is a serious case of concern. The Parliament is concerned about it. And the judiciary, which is comprising of the lawyers, are also should be concerned. They must take steps. Yes, whoever high, even the Chief Justice is also below the cause of justice. Chief Justice, if he is not contributing to the cause of justice, he is also guilty of polluting the stream of justice. Therefore, the concept is rule of law. Whosoever thou art, the law is above you. Applies to the Chief Justice of India also. Applies to judges, applies to senior advocates, lawyers, all of them. Therefore, independence of judiciary, independence of legal profession, yes, it's a very important thing, especially in Kalikopul matter and the Karnan matter. The Supreme Court Bar Association needs to ask for a proper resolution on the issues prior to initiation of contempt proceedings. This is my personal opinion with all great respect. Because I am sure my judges of the Supreme Court are most honest. Yes, they are correctly outraged. However, the mechanism for disposing the complaint prior to person being held for contempt is required in the interest of justice. I might be wrong, but this is my opinion. It's in the interest of justice, and I must be having the freedom to tell it. That is independence of the legal profession. See, you cannot call names, judges. You cannot call names on judges. You cannot tell it is corrupt. Somebody else. These are all serious misconduct. However, when there is grave allegations, everyone is under the law, not above the law, and there must be sufficient procedural and substantive safeguards to ensure that the person who is aggrieved by any misconduct is properly addressed. That the Union government is addressing, but there is no proper meeting of minds between the judiciary and union government, which soon will be solved. And as regards the Law Commission report, I am very sorry to tell, even though the popular sentiment of the lawyers are there, that it is beyond, that judiciary is trying to interfere, retired judges are appointed in disciplinary proceedings. I am sorry, that is not the area of lawyers. Lawyers can give their grievances. However, the grievances should be within accepted modes. They cannot commit boycott. They cannot give resolutions for boycott in the name of showing protest. And it is very sad that Manan Kumar Mishra, the Bar Council of India chairman, I have seen WhatsApp, he must have given clarification that he has advised all bar associations to burn the copies of the Law Commission recommendations in the lunch hour, if I am right. Yes. It is very sad and it is highly contemptuous of ex-Captain Harish Upal's case and common cause case. Such a call cannot be made for boycott of courts or for burning of any copies. It is highly unbecoming of lawyers and unbecoming of Manan Kumar Mishra, who himself had suspended more than 25 lawyers for similar offences in Tamil Nadu. And now he is a devil's advocate. It's very bad, it is. Such conduct cannot be permitted. This is not the legal, this is not the independence of legal profession. You see, it's a noble profession, and if you do not display trust of the system, if you do not display trust within the accepted parameters, and you must contest the law commission. If Mr. Manan Kumar Mishra is free to kindly go to the Supreme Court and demand stay of that particular recommendation, or after it is ready in the legal term. Instead, he cannot do such a roadside theatrics. It is demeaning of the noble profession, and it is very sad that independence of legal profession is defined like this. Kindly see, independence of legal profession is not this. The lawyer is a noble citizen. He must conform to the cause of justice and the duty to the court, and as officer of the court, he cannot indulge in such roadside cheap theatrics. This is not in any manner an independent legal profession. So, if somebody is asking you whether this protest is justified, the answer is this is in no manner justified, and you are only free to go as per law and contest that legislation before the courts under the writ side. So, this is the answer, and this is how the public trust is built. Lawyers, public trust, unless you are acting nobly. So, a burning copy with a lawyer in robes is no advertisement for the public trust the people can place on the lawyers. So, public trust is by exemplary conduct and a sense of duty to the court. That is how the public trust is maintained. It should be of the highest order. I should recollect Gandhi's great father of our nation. Gandhi's act. See, once before a magistrate, he was faced with a problem. He had a point that was against his client, and his client was guilty of some perjury. He placed it before the court, even though it is against the client, and excused him excused himself, because the fact is there, he cannot go against. He asked for conviction of the client on that basis only. That is the exemplary conduct. That is how the trust is maintained. Public trust is maintained because of such acts, not because of any fast operator lawyer or smart lawyer browbeating the court. So, the conduct is, even though client instructions are there, the client should very well know that he must behave, he must be true to the court to expect the lawyer to function as his lawyer. Otherwise, he will be the officer of the court. Don't make, the client should know that his lawyer should not become an officer of the court, and when he is an officer of the court, the client has nothing against him. Therefore, he cannot be protected that way. So, these are, you must see, this is the concept by which you understand. Best of luck. In leading cases, I will be discussing just to understand question paper, how to answer. It's an open book question paper, and the hints of the Supreme Court reports will be supplied to you. Therefore, what should be done in leading cases is, you must understand the concepts, the case law and the concepts before. The main concepts of a particular case law you must be understanding. And it is likely that last year's question paper won't be repeated. Therefore, for example, Minerva Mills, Maneka Gandhi case, D.K. Basu, Bachan Singh, SCOR case will be repeated. I think that cannot be. I am sure you can now ignore most of the last year's papers. Of course, you must be aware of the concepts. However, even though the Supreme Court AOR case on the NJSC, which was quashed, was asked, definitely this year also it will be asked. Why? Because the problem that sought to be cured has not cured. You see, the central government and the union judiciary are in conflict over settling the memorandum of procedure for appointment of judges, for disciplinary proceedings and mechanism for entertaining complaints against judges by citizens and clients and litigants. Therefore, since that issue is pending and there is a large scale hiatus in the appointment of judges, definitely that question will be asked in one form or the other. So that is that you see, according to me, the judges appointment and the NJSC quashing is worth 50 to 75 marks. Yes, not only will it be asked in the leading cases, it will also be asked in the Supreme Court practice and procedure, and might be drafting also, who knows. 50 marks to 75 marks, it is a very vital part. So it is good to go through the NJSC quashing case, SCAOR case, from the SCAOR 1, SCAOR 2, SP Gupta's Union of India, that was prior to SCAOR, the hierarchy, SP Gupta, SCAOR, SCAOR 1, SCAOR 2. Subhash Sharma, all these cases are there. That is a very important thing. It decided that Chief Justice shall be consulted in all matters of appointment to higher judiciary. That is the High Court and Supreme Court. There is no compromise on that. So the word shall in Article 124 was utilized by the Supreme Court to mean that shall means effective consultation, prior consultation, and proper meetings of mind. It need not be conclusive in one side, but there must be effective consultation. So that was not done. Now they are doing, the MOP is vetted, Law Ministry and the Supreme Court are now in the act. Soon a common compromise and a good solution will arise. So this aspect you must concentrate. 25 marks, likely to get 100%. So that is almost 1/4 of the paper. So that you must understand, read in the right perspective, SP Gupta, SCAOR 1, and understand them also. Then come to the court. Judges transfer, Sanjay Sankalchand case. All these things you need to understand in the right perspective. Now, apart from that, you see, leading cases is very important for practice and procedure. I will tell you how. Several practice and procedure cases are linked to leading cases. For example, 11(6) under the Arbitration Act, that is SBP Oil Company, where it was held that appointment of arbitrator is a judicial function. So what did it overrule? It overruled Konkan Railway case, which held that appointment of arbitration is a administrative function. So in this case, there is this dissenting opinion of Justice SP Sinha. It is, you see, I do not know whether the Supreme Court reports hints also have the dissenting opinion, but I think it is important to know the dissenting opinion. For example, it is important to know the dissenting opinion of Justice Chalameswar in the 6:1 judgment of in the lone dissenting judge in the SCAOR case. You must read it, how he has told what is his interpretation on the prior consultation and the primacy of the Chief Justice and the appointment of judges. So these points, they give you good argument capacity and good ideas on the counter concepts. So you must be aware, of course, since the law declared by the Supreme Court is that of the majority. Under Article 145, Supreme Court functions by majority. The law declared is that of the majority of the judges. It's not the minority of the judges, not the dissenting judges. It is a majority. Therefore, so law declared can be only that of the majority. However, for a conceptual clarity and for getting good points, you have to read the dissenting opinion. It's important that you read the dissenting opinion. So that was with respect to leading case, which is overlapping in practice and procedure as well as leading case. Another is this AR Andulai versus RS Nayak and Rupa Hurra and Ashok Hurra. You see, this combines Article 137, 142 and 32. It's a combined reading of Article 137, 32 and 142. It is a plenary power of the Supreme Court, residuary power of the Supreme Court to do complete justice in the ex debito justitia, in the interest of justice. So this is a very open-ended and wide definition of the jurisdictional powers, the plenary powers of the Supreme Court that was discussed in AR and Clay, where the Supreme Court had held that it can correct its own wrongs in the interest of justice, and no procedural or substantive deficiency would stand in the way of the Supreme Court in correcting its own wrongs. It was further enlarged in Rupa Hurra versus Ashok Hurra, where the Supreme Court had held that it can correct its own wrongs on a petition that is duly certified by a senior advocate under Article 32, that the grounds to be laid out in Rupa Hurra and Ashok Hurra has been satisfied in the curative petition, and the grounds are: the judge who had given the judgment should not have any connection in that case. That was not made available to both the parties. The knowledge was lacking. Other point is natural justice failure. If proper summons or proper right to participate and oppose or support a case to a party has not been given. These are the two grounds on which the Rupa Hurra prescribes filing of a curative petition, and strictly on those grounds only the senior advocate can give his certificate. And now on the basis of Rupa Hurra curative petition filing, which was as per the orders of the Supreme Court, in the 2013 amendment to the Supreme Court rule, Supreme Court has created a separate order section for curative petition. That also you need to learn. These are the developments. So other is the this is with respect to Article 137, 142 and Supreme Court rules with respect to review and Article 32. These two cases also are likely to get reported, likely to get questioned in both practice and procedure as well as in leading cases. This also is worth 25 to 50 marks. I was telling 25 to 50 marks I was giving for SCAOR case read with the recent SCAOR 2, SCAOR 1 and 2. They are also having high weightage. See, then there are several PAL cases. So you must read these leading cases as a cluster of cases, as a PAL cluster. Education matters, then corruption matters, then 142 complete justice, directions given to Supreme Court, like that. There are several areas where the matters are connected to each other, but they are leading cases. So you must understand those matters which are interlinked to each other and what they held, and that is easier to remember and also read. For example, TMA Pai and PA Inamdar can be clubbed as education matters. Then Minerva Mills and L. Chandrakumar are basic structure. The jurisdiction of Supreme Court cannot be taken away. That was Chandrakumar. Any special statute or tribunal cannot take away the powers of the Supreme Court. Minerva Mills is nothing but the basic structure of the Constitution and harmonious instruction and harmonious interpretation of Part 3 and Part 4 by the Supreme Court. They should not be interpreted in such a manner that they are opposing each other, but in such a manner that both work with each other for the betterment of the citizens. So that is then you see on medical negligence, right of the patient and compensation to be awarded in case of medical negligence. There is this landmark case on Malay Kumar Ganguly versus Sukumar Mukherjee. Then Article 21 rights, you can take Zahira Sheikh case. Selvi, Zahira Sheikh was with respect to fair trial, requirements of fair trial, transfer of case from one state to another for ensuring fair trial, and also false testification and false evidence given by any petitioner. And also Selvi is nothing but right to privacy and right to life, and right against double jeopardy, right against self-incrimination, not double jeopardy, right against self-incrimination, conduct of the test, the truth finding test, serum test, mapping test, brain mapping, these whether they are constitutionally correct. So this is a landmark judgment on Article 21. So these are Article 21 cases. As I already told, this is M. Nagaraj's Union of India. That is with respect to rights of SC/ST. Interpretation of Article 16(4) and right of SC/ST to get promotion, reservation in promotion. What are the basis on which reservation in promotion can be given to SC/ST? The objective test and the subjective test. That SC/ST representation should not be adequate, and any overstaffing of SC/ST should not lead to decline in efficiency of the cadre. So if these two things are satisfied, then automatically there is a reservation in promotion that can be saved. Otherwise it cannot be saved. So the quantifiable data with respect to these two aspects were discussed as very important in the M. Nagaraj case. So any state which is trying to make provisions for reservation in promotion, it should first have the exact data and subject it to the tests, quantitative and qualitative, and then only reservation in promotion can be upheld. It also upheld the reservation case, the first reservation case. That is the first reservation case, that was reservation case 50%, 49% reservation. That was upheld by this M. Nagaraj. And the other case is Aruna Shanbag. That is with respect to suicide. Suicide by right to suicide. Right to commit suicide or right to mercy killing, euthanasia, concept of euthanasia, whether that can be permitted. The Supreme Court held that yes, if a person is unable to take his own life decision, then definitely seeing the condition of the body and the state of the patient, a High Court monitored committee can definitely look into it and suggest whether mercy killing would be the right choice. That was Article 21 landmark judgment. Then we have Swami. You see, then Society for Unaided Private Schools of Rajasthan, which is Union of India. That is also educational matter in private institutions. It discussed state reservation in private institutions, whether that is maintainable. That's an important case. Then you see, with respect to natural resources, there are two cases. One is a CPIL, Center for Public Interest Litigation. This is all, and the other is a special reference number 1 of 2012. This case is also concerned with the advisory jurisdiction of the Supreme Court under Article 143. That can be used in the practice and procedure also. Therefore, special reference 1 of 2012, that is with respect to allocation of natural resources and the doctrine of public trust. All the natural resources are held in public trust, and auction is the best manner of managing natural resources for commercially managing and procuring the best rate for natural resources that are held in public trust by the state. So that is an authority on that. And subsequent to the order of the Supreme Court in CPIL case, the central government through the President of India had sought the advisory opinion. And that is also a good case on advisory jurisdiction, whether on a decided matter that was judicially determined, any similar question on the same aspect can be made, whether there is any distinction between the advisory opinion sought and the judicially determined matter, and what to do if there is no distinction, where they are both the same. So the Supreme Court had authoritatively discussed the scope of advisory jurisdiction in special reference number 1 of 2012. And with respect to state right, when a person seeks CBI investigation into a cognizable offence that was committed within the boundaries of the state, whether there is need for seeking the state permission to appoint a CBI inquiry. That was discussed in the state of West Bengal, which is Committee for the Protection of Democratic Rights. So, Supreme Court held that when there is a commission of offence giving rise to a cause of action within the local limits of a state, the Supreme Court can very well appoint, the High Court can very well appoint a CBI inquiry. There is no need for the state government to be sought, state government's opinion to be sought. Then there is this Vodafone International Holdings versus Union of India. This is a landmark judgment on taxation, avoidance of taxation. What would amount to an avoidance of taxation? Whether a legitimate arrangement towards tax structures and managing them would amount to a avoidance of taxation. The Supreme Court held that if there is a legitimate arrangement for managing tax and avoiding tax, then it cannot be found fault with. It upheld the legitimate arrangement. And it also held when it can open the corporate wheel if there is any siphoning of funds or evasion of tax by corporates. That's a landmark judgment on that. And you see, with respect to pensioners' rights, T.S. Nakara, whether pension is a right and whether there can be a fixation of arbitrary cut-off date to discriminate between two sets of pensioners. And you can see D.K. Basu's case. D.K. Basu and Vishaka. These are continuing mandamus. They are the best examples for continuing mandamus, where the Supreme Court has kept matters pending and repeatedly and constantly observing the progress of the implementation of the orders by keeping a fixed date and monitoring the progress made by the state authorities in implementing its orders by way of mandamus directions. It's a landmark case on that. And you see, where there is legislative inaction, Supreme Court had made several directions that later became the basis for a statute. This the best example is Vishaka case, where the direction of the Supreme Court regarding harassment of women at workplaces, sexual harassment, later became the basis of the Sexual Harassment Act. The findings of the Supreme Court, the directions, later formed the basis of the legislation, because the Supreme Court made intervention by way of directions after seeing the legislative inaction in the particular area. So this is a good example for judicial legislation. So that is one area. And Indira Sahani, it must be read along with M. Nagaraj. Indira Sahani is with respect to reservation. subject to a maximum of 50% with allocations for OBC, SC and ST. It upheld the reservation, however the ceiling was fixed at 50%. So it's a landmark judgment, and within the 50% there is a possibility of reservation, and 16.4 reservation in promotion post. But Indira Sahni was mainly dealing with entry level post, that is first. It was expected that in promotion the candidates, since they were given the initial benefit of reservation, they should perform in equal footing and show their caliber and that get elevated. So that was discussed in M. Nagaraj, and they stipulated that quality and quantity test, that is objective and subjective test, that there should not be overstaffing and declining efficiency, declining efficiency owing to appointment of SC/ST candidates. And second was the quantifiable data with respect to the SC/ST candidates needs to be analyzed so that the reservation in promotion can be accepted. 16.4 was upheld in Indira Sahni as well as in this M. Nagaraj case. Like this, you see, there are several cases. I think I have discussed at least some 15-20 cases. You see, the point is you must have a basic understanding of the law settled in these leading cases, and you must have a good look in the question paper and see what is actually asked in the question. And after understanding the question, after understanding what point needs to be given to the examiner, that then only you must write. Simply in this leading case, people know many things. Their judgments are very big. Minerva Mills is a landmark judgment. They are running to hundreds of pages. Keshavananda Bari landmark judgment, hundreds of pages. That doesn't mean you can write all those things in the answer. Answer is most probably law declared, law settled ratio, and in that they will be asking some part that requires your understanding and attention. That only you must answer. You must not answer whatever is law declared. In the law declared, they would ask specific aspects, or specific aspects where there was a difference of opinion between judges, or specific aspects where certain concepts were explained by judges in the majority opinion. So these are the things that will be asked, and these are the things you must specifically answer. So because it's a open, there is a danger in this paper. In drafting and leading cases, there is danger. Even best candidates will fail because they don't know how to manage time, and also they know too much and they write too less. Mainly because they don't know what to write and what exactly you must present. That is lack of practice. So first, you must, in the leading cases, you must clearly read the question paper in a cool manner. Just spend half an hour, no problem. You are not expected to write 4 pages, 5 pages. Only 1 page also is enough. Exactly, you must have the knack of getting the right answer that is required from the examiner. So for that, it is always, see, even though it's an open book, it is always know the concept exactly, so that the concept can be stressed heavily in the first point itself. So the danger of not reading and going to the open book exam is, you will be writing all rubbish. See, there are 20 pages for a particular leading case. You will be writing that which is not required at all. So what is required from you only should be written. So for that you need to, like in drafting, here also you need to analyze and make small notes. 3 or 4 question papers you must solve and show it to some knowledgeable person, AO or like person, or some senior advocate, or better still the examiners who advise you, and ask them to guide, give so 2 or 3 ideas, and you must know how to avoid the wrong answers and how to give the right answers. That is the total trick